Just think for a second about how much of our lives really is digital now. Ordering stuff online, banking apps, even healthcare apps, talking to your doctor.
Absolutely. We're constantly sharing bits of personal information, aren't we?
We really are, and it's this amazing convenience, but it brings up that fundamental tension, doesn't it? How do we actually protect our privacy when, well, so much of our data is just out there?
It's a huge question, and countries everywhere are wrestling with it. Today, we're going deep into India's really groundbreaking answer. It's the Digital Personal Data Protection Act 2023, uh, DPDPA
For
for
DPDPA, right? Got presidential assent August 11th, 2023.
that's the one.
So our mission today for you listening is to really get you a clear, comprehensive understanding of this. How your digital personal data is protected now in India. What are your rights? How does this new law stack up against, what was there before? And even against global standards like GDPR.
Yeah, and we'll unpack some fascinating details too, like what actually happens if your data gets breached, what do businesses have to do now, and some quite unique ideas in this Indian law.
And look, why should you care? This isn't just for lawyers, right? If you use digital services in India, maybe you run a business there, or you're just, curious about how data privacy is evolving globally.
Then this deep dive is really essential. It impacts pretty much everyone connected to India's digital sphere.
Okay, so let's set the scene. What was it like before the DPDPA? You mentioned a patchwork earlier.
Or patchwork is a good way to put it. Historically, India just didn't have one single overarching law for data protection. Now, the courts, including the Supreme Court, they did recognize privacy as part of the fundamental right to life and liberty.
So it was recognized constitutionally, but not in a specific data law.
Exactly. The legal framework was, well, fragmented. You had bits and pieces here and there.
So what did that mean practically for, say, me trying to protect my data or a business trying to follow the rules?
That's a key point. For individuals, it often meant confusion. What rights did you really have? How could you enforce them? And for businesses, compliance was kind of piecemeal. The main law was the Information Technology Act, the IT Act from 2000.
Okay, the IT Act. I've heard of that.
Yeah, and the 2008 amendments, plus some privacy rules from 2011. But these were mostly focused on information security.
Ah, security, not necessarily privacy rights.
Precisely. It was more about protecting the systems. They did define something called sensitive personal data or information, SPDI, that covered things like passwords, financial data, health info, biometrics.
Okay, so some specific data types got special mention, but what were the sort of loopholes or limitations for companies back then?
Well, liability could sometimes be, shall we say, diluted. If there was a breach involving unauthorized use of data, a company might avoid hefty penalties if they could argue they had no knowledge or they'd used best efforts.
Best efforts. Sounds a bit vague.
It could be. The maximum penalty for that kind of unauthorized use was around $222,000 USD equivalent. But it's worth saying, if you intentionally messed with computer source code or data deleting it, altering it, that was criminal.
Okay, so intent mattered a lot.
Big time. That could mean up to 3 years in prison or a fine up to maybe $440,000. So serious consequences for deliberate acts.
Were there other laws that sort of tangentially touched on data, maybe things not obviously about data protection?
Yes, definitely. People got creative. Sometimes the Indian Penal Code was used, interpreting data theft as misappropriation of movable property.
Movable property, data, that's a stretch.
A bit of a legal workaround, yeah. It shows how they tried to fill the gaps. Plus, intellectual property laws, copyright applies to databases in India, and then specific acts like CSAR for credit information, which was quite strict.
So given this fragmented legal scene, did industries like software and outsourcing just wait around, or did they do anything themselves?
Now this is where it gets really interesting. The industry, especially groups like NASSCOM, didn't wait. They proactively put in place incredibly stringent security measures. Really quite impressive.
Like what? What kind of measures are we talking about?
Think high security, armed guards at some BPO centers, microchip swipe cards, no bags or briefcases allowed in work areas, no mobile phones on the production floor.
Wow. Seriously? No phones?
Seriously. They restricted or even banned internet and email at workstations, encrypted key information. constant CCTV monitoring.
It sounds like Fort Knox for data, but self-imposed by the industry.
Pretty much. It wasn't just about ticking boxes, it was about building trust, especially with international clients who expected high standards. It showed a real commitment from the private sector, even before this comprehensive law.
Okay, so that's the backdrop. A mix of laws, court interpretations, and industry self-regulation. And out of that, we get the DPDPA. A new era, you called it.
It really feels like it. The Digital Personal Data Protection Act, 2023. Again, August 11th, 2023, assent. It's India's first truly comprehensive data protection law. It's expected to roll out in phases, but the signal is clear. Things have changed.
What's its main goal? Is it just about protecting users, or is there a balance?
It's explicitly dual purpose. It aims to recognize, one, the individual's right to protect their personal data, but also, two, the need for businesses and others to process that data lawfully for legitimate reasons.
Finding that balance. Okay, let's get into the key players, the who's who. Who's the data principal?
The data principal is you, the individual, the person that the data is about. Simple as that. And importantly, for kids under 18 or persons with disabilities, their parents or legal guardians step into that role.
Got it. And the data fiduciary.
That's the organization or person who decides why and how the personal data is processed. Think of them like the controller in GDPR terms. They're calling the shots on the data use.
Okay, fiduciary controls. Then who's the data processor?
The processor is whoever processes the data on behalf of the fiduciary. So maybe a cloud provider or a payroll company working under instructions from the fiduciary.
Right. Now, you mentioned unique concepts. Is there anything totally new here compared to, say, GDPR?
Yes, the consent manager. This is genuinely novel. It's an entity registered with the new Data Protection Board that acts as a kind of intermediary for your consent.
An intermediary. How does that work?
Imagine a single platform or service where you could go to see, manage, give, or even withdraw your consent for lots of different services you use. It's designed to make managing consent much easier for you, the data principal.
That sounds potentially game-changing for user control. Okay, and what about significant data fiduciaries, SDFs? Who are they?
Good question. These aren't just any data fiduciaries. The government can designate certain ones as significant.
Based on what? Size?
Size is part of it, the volume of data they handle, but also the sensitivity of that data, the potential risk to people's rights if something goes wrong, and even the impact on India's sovereignty, security, or public order.
So the big players, or those handling really critical data?
Exactly. And they'll have extra rules to follow, which we'll get to.
Okay. So what data does this law actually cover? What's the scope?
It's specifically about digital personal data, data that's processed electronically within India. That includes data collected digitally or data collected offline, maybe on paper, and then digitized later.
So if it ends up digital, it's covered? Does it apply outside India too?
Yes, it has extraterritorial reach. If a company outside India is processing personal data in connection with offering goods or services to people inside India, then the DPDPA applies to them too.
Ah, so that foreign app developer we talked about earlier, they're caught.
They would be, yes, if they're targeting users in India.
Are there any important things it doesn't apply to? Exemptions?
Yes, a few key ones. It doesn't apply to data processed by an individual for purely personal or domestic reasons. You know, your own address book or family photos.
Like,
And this is a big one. It doesn't apply to personal data that you yourself made publicly available, or data that's made public because of a legal requirement.
so if I post my opinions and maybe some personal details on my public blog or social media.
That specific public sharing wouldn't fall under the DPDPA's processing rules. It draws a line between private processing and public domain data. There are also exemptions for government processing in the national interest, security, and so on, and for research, archiving, or statistics under certain conditions.
That public availability distinction is quite clear. Okay, so how can companies actually process data now? What are the legal grounds?
There are basically two main paths. One, get the data principal's consent. Two, process it for certain legitimate uses defined in the Act.
Consent or legitimate uses. Let's start with consent. What does consent look like under DPDPA? Is it just clicking, I agree?
No, it's a much higher bar now. Consent has to be free, specific, informed, unconditional, and unambiguous. It needs a clear affirmative action. Think ticking a specific box, not just assuming consent from silence.
Right, no pre-tick boxes.
Exactly. And consent is limited to the data that's necessary for the specific purpose you're told about. A weather app probably doesn't need your contact list, right?
Definitely not.
So it can't ask for it just because. The request for consent must be in clear, plain language. And you have to have the option to get it in English or any of India's 22 official languages listed in the Constitution.
Accessibility is key. What about taking consent back?
Crucially, you have the right to withdraw your consent anytime. And withdrawing it has to be as easy as giving it was.
Easy in, easy out. That really shifts the power.
It does. It makes consent a truly ongoing choice for the user.
Okay, what about the other path? These certain legitimate uses where consent isn't needed. What falls under that?
There are specific situations listed. One is when you voluntarily provide data for a purpose,
Yeah.
and you haven't indicated you object, like giving your phone number at a shop counter for a receipt. You offered it for that purpose.
Okay. Sort of implied consent through voluntary action for a clear purpose. What else?
Processing by the state for providing benefits, subsidies, services, things like that, especially if you've previously consented or the data is already in a government database they can access.
Government functions, basically.
Yes, and also state functions related to sovereignty, security, public order.
Hmm.
Also, complying with laws or court orders, including foreign court orders in some civil or contractual cases.
What about emergencies?
Absolutely. Medical emergencies, threat to life or health. Public health situations like responding to epidemics, disaster management, or breakdown of public order. These are considered legitimate uses where consent isn't required beforehand.
And employment. That often involves sensitive data.
Yes, employment is another category. Processing, necessary for things like preventing corporate spying, protecting trade secrets, providing employee benefits, verifying attendance, sort of the necessary nuts and bolts of the employment relationship.
So it seems like these legitimate uses cover quite a bit of ground, particularly for government and essential services and maybe common business practices.
They do. It's a pragmatic approach, carving out specific exceptions where seeking explicit consent might be impractical or counterproductive, especially for public interest functions or standard operational needs. It's definitely a different approach than relying heavily on a broad, legitimate interests ground like in GDPR.
Right. It seems more defined, less open to interpretation, perhaps. Okay, so we know how data can be used. Let's flip it. What are my rights as a data principal? What power do I have?
You have several key rights. First, the right to access information. You can ask a data fiduciary for a summary of the personal data they have about you, what they're doing with it, and who else they've shared it with.
So I can see what they have and who they send it to.
Mostly, yes. The only exception is sharing related to investigating crimes or cyber incidents. They don't have to disclose those specific sharing details.
Okay. And what if the information they have is wrong or outdated?
Then you have the right to correction and erasure. You can ask them to correct inaccurate data, complete incomplete data, update old data, or erase data that's no longer needed for the purpose it was collected for, or if it's not required by law anymore.
So access, correction, erasure, pretty fundamental. How do I actually make these requests or complain if something's wrong?
That leads to the right to grievance redressal. Every data fiduciary and those consent managers we talked about must have an easily accessible and effective way for you to raise grievances. And crucially, you have to use their system first.
So I can't just go straight to the authorities?
No, you need to try and resolve it with the company first. Exhaust their internal mechanism before escalating it to the Data Protection Board.
That makes sense. Give them a chance to fix it. Now, you mentioned a really unique right earlier, the right to nominate. Tell me more about that.
Yeah, this is quite forward-thinking. It allows you, during your lifetime, to nominate another person who can exercise your rights under the DPDPA on your behalf in case of your death or incapacity.
So, like a digital executor for my data rights.
Kind of, yeah. It provides a way to manage your digital footprint and privacy preferences even when you can't do it yourself. It's about your digital legacy, in a way.
Interesting. Now, with all these rights, for me, the user, does the law put any duties on me too? Is it a two-way street?
It is. The DPDPA includes duties for data principals as well. You shouldn't impersonate someone else when providing data. You shouldn't suppress relevant information when applying for documents or services. You shouldn't file false or frivolous complaints.
Okay, so be truthful and don't abuse the system.
Exactly. And when you ask for corrections, you need to provide authentic information to support your request. It helps maintain the integrity of the whole process.
Right. So shifting back to the companies, the data fiduciaries, what are their big obligations? What must they do?
Okay, big ones. First, overall accountability. They're responsible for complying with the Act, not just for their own processing, but also for anything done by a data processor on their behalf. That means having a solid contract with processors.
So they can't just pass the buck to their vendors.
Nope. They also have a duty regarding data quality. They need to make reasonable efforts to ensure the data they use is accurate and complete, especially if it's used to make decisions about you or if it's shared with another fiduciary.
And security. That's got to be huge.
Absolutely critical. They must implement reasonable security safeguards, both technical and organizational measures to prevent data breaches. What's reasonable will likely be detailed further in rules, but the obligation is clear.
And if a breach does happen, despite safeguards.
Then the breach notification duty kicks in. This is significant. If a personal data breach occurs, the Data Fiduciary must notify the Data Protection Board of India and every single affected data principal.
Every affected person, regardless of the breach size or risk.
That's how the Act reads currently. Unlike GDPR's risk-based threshold, the DPDPA seems to mandate notification for all personal data breaches to both the board and the individuals. There's a very broad notification requirement.
Wow, that can mean a lot of notifications. What about keeping data forever?
No, there's a duty for data retention and erasure. They must erase personal data once the purpose for collecting it is met, and it's no longer needed for legal or business reasons.
Okay.
Or, if you withdraw your consent, they generally have to erase it, unless retention is required by law.
So purpose, limitation, and deletion. Standard stuff, but crucial.
And they need to be reachable. They have to publish the contact details of a data protection officer, if they're required to have one, or at least a point person who can answer your questions about how they process your data.
Okay. What about kids' data? Always a sensitive area. Any special rules?
Yes, very strong protections for children, defined as anyone under 18. Verifiable consent from a parent or legal guardian is absolutely required before processing any child's data.
Verifiable consent. So more than just a tick box, presumably.
Presumably, yes. The rules will likely specify how that verification happens. Also, data fiduciaries must not process children's data in any way that's likely to cause harm to the child's well-being.
A duty of care specifically for kids.
Exactly. And critically, no tracking, no behavioral monitoring of children, and no targeted advertising directed at children is allowed under the Act. There might be some exemptions later for processing deemed verifiably safe, but the default is very protective.
That's a strong stance. Now back to those significant data fiduciaries, the SDFs. What extra homework do they get?
They have several additional obligations because of the scale or sensitivity of their processing. They must appoint a data protection officer, a DPO, based in India. This DPO reports to the board or equivalent management and is also a point of contact for grievances.
So an internal watchdog based in India.
Right. They also need to appoint an independent data auditor to carry out regular data audits, and they have to conduct periodic data protection impact assessments, DPIAs.
DPAAs, what are those?
They're basically risk assessments. The SDF has to proactively assess the potential risks of their data processing activities to the rights of data principals and figure out how to manage those risks. Plus, there might be other measures prescribed specifically for SDS later on.
So higher risk processing means significantly more compliance hoops to jump through.
That's the idea. More obligations for those handling more sensitive or large volumes of data.
Okay, so we have all these rules, rights, obligations. How is this all enforced? Who makes sure everyone's following the rules?
The central enforcement body is the newly established Data Protection Board of India. It's designed to be an independent body.
The Data Protection Board, what does it do?
Its main job is to adjudicate on non-compliance. It's intended to function primarily as a digital office. You file complaints online, hearings might be virtual. It can investigate breaches, either based on a complaint from someone like you, or if the government refers a matter to it.
And what can it do if it finds a breach?
It can order urgent remedial measures, it can conduct inquiries, and importantly, it can impose penalties for non-compliance.
What kind of powers does it have to conduct these inquiries? Can it compel people to cooperate?
Yes, it has powers similar to a civil court. It can summon people, demand documents, conduct inspections. It can also issue warnings or even impose costs if it finds a complaint was false or frivolous.
So it has teeth. What if I disagree with a decision the board makes?
There's an appeal mechanism. Decisions of the board can be appealed within 60 days to the Telecom Dispute Settlement and Appellate Tribunal, TDSAT. TDSAT also intends to function digitally as much as possible.
Okay, an appeal route. Is there any way to resolve things without going through the whole penalty process?
Interestingly, yes. The board can accept what's called a voluntary undertaking from an organization or person regarding compliance. If they accept this undertaking, it can actually bar further proceedings on that specific matter, provided the undertaking is followed. It offers a potential path for remediation.
A sort of settlement option. Now, let's talk money. The penalties. You mentioned they were substantial.
Very substantial. The Act lists maximum penalties for different types of violations. For failing to take reasonable security safeguards to prevent a breach, the penalty can be up to 250 crore rupees.
250 crore. What's that roughly in dollars?
Roughly around 30 million US dollars. It's a significant amount.
Wow. Okay. What about other breaches?
Failing to notify the board or the affected individuals about a data breach. That could be up to 200 crore rupees, maybe $24 million USD. Breaching the special obligations related to children's data, also up to 200 crore.
And for those significant data fiduciaries, if they slip up on their extra duties.
Breaches of their additional obligations can attract penalties up to 150 crore rupees. These are definitely figures designed to get attention and ensure compliance.
Where does that penalty money go?
It gets credited to the Consolidated Fund of India, which is essentially the government's main account.
Okay, let's shift to data going outside India, international transfers. Does the DPDPA lock data down within India's borders?
Not necessarily. The default position under the DPDPA is that cross-border data transfers are generally permitted. However, the central government has the power to restrict transfers to specific countries or territories by notifying them.
So a sort of blacklist approach rather than a whitelist?
Kind of, yes. Transfers are okay unless the destination is on a restricted list. Also a key point. If any other Indian law provides for a higher degree of protection or restriction on data transfers for a specific sector, that other law will prevail over the DPDPA's general permission.
So you still need to check sector-specific rules. Does the DPDPA itself require data localization, meaning data must be stored in India?
No, the DPDPA itself doesn't impose a general data localization mandate. But, as you hinted, other laws do. For example, the Reserve Bank of India has rules for payment system data localization. The Companies Act has rules for keeping books of account in India. Insurance regulators have their own requirements.
So no localization in this act, but it still exists elsewhere in Indian law for certain sectors.
Exactly. You have to look at the whole picture.
Okay, now for the big comparison everyone thinks about, DPDPA versus GDPR, Europe's big data law. What are the main differences? Where do they diverge?
There are some really key differences. First, scope. DPDPA focuses on digital personal data and, remember, explicitly excludes data made publicly available by the user. GDPR covers all personal data, regardless of format, within its scope, and doesn't have that broad public data exclusion.
Right, digital versus all, and that public data point. What else?
A really material difference is the legal basis for processing. We talked about DPDPA having consent and certain legitimate uses. GDPR has more bases, including necessity for the performance of a contract and, crucially, legitimate interests of the controller.
And DPDPA doesn't have those.
No. The absence of contractual necessity and a broad legitimate interests basis is a major divergence. It means businesses operating under both regimes might need different justifications for the same processing activity depending on whether it's governed by GDPR or DPDPA. They'll likely rely more heavily on consent under DPDPA.
That could significantly change how some services are designed or offered in India. What about breach notification differences?
Another big one. As we said, DPDPA requires notifying the board and all affected individuals for every personal data breach. GDPR has a threshold. Notification to the regulator is required usually within 72 hours, but notification to individuals is only required if the breach is likely to result in a high risk to their rights and freedoms.
So DPDPA is potentially much broader, less risk-based on the notification front.
Yes, broader notification seems to be the intent. And GDPR has that 72-hour clock for notifying the authority, which the DPDPA doesn't explicitly state, though promptness will likely be expected.
What about those unique DPDP features? Do they have GDPR equivalents?
Not directly. The consent manager concept is unique to India. The right to nominate for death or incapacity is also not a standard feature in GDPR. And the specific category of significant data fiduciaries, with their prescribed extra duties like the India-based DPO and mandatory audits, is also a DPDPA-specific construct.
Are there rights in GDPR that aren't in the DPDPA, things individuals might miss?
Yes, a few notable ones. The DPDPA doesn't explicitly grant a right to object to processing in the same way GDPR does. It also doesn't explicitly provide for data portability, the right to get your data in a machine-readable format to take to another service. And there isn't an explicit right related to automated decision-making and profiling like in GDPR.
So some key differences in the bundle of rights as well. And just to remind listeners about the first step for complaints.
Absolutely. Under DPDPA, remember, you must go to the data fiduciary's grievance mechanism first. Exhaust that remedy before you can take your complaint to the Data Protection Board. That procedural step is important.
Okay, so wrapping this deep dive up, it's clear the DPDPA is a really significant moment for data protection in India, isn't it? A major leap from that old patchwork system.
Without a doubt, it moves India towards a comprehensive, principles-based framework. It's designed to empower individuals like you with clearer rights over your digital data, while putting very clear and potentially very costly obligations onto businesses.
And it's not static, right? You mentioned it's an umbrella law.
Exactly. This is the main act. But many specifics will be filled in by supplementary rules that are still being developed. So the landscape is still evolving. It's the foundation, but the building is ongoing.
So as we see different countries tackling digital privacy in their own ways, it leaves us with something to think about. Does India's unique approach, the consent manager, that broad breach notification, but maybe fewer individual rights compared to GDPR, does this offer a different kind of model?
A model that tries to balance individual rights with maybe the specific needs of a rapidly digitizing economy and national priorities. Or does the absence of certain rights signal a fundamentally different philosophy about data control? And what does all this mean for how data will flow across borders in the future?
Lots to consider as this new chapter in India's digital story unfolds.